you.
This court is resumed. Please be seated.
Justice Hennessy, you'll see in my overview that my next topic is distribution. And this specifically refers to the situation posed by Namaygoosisagagun. Our arguments on this are already set out in our written submissions, and I summarized them in the overview on Friday. And I understand we may be hearing from counsel for Namaygoosisagagun. So in those circumstances, I would direct you to our written submissions. I have only one point I'd like to make, and that is this. Canada's proposed remedy is for this court to hold back a percentage of the total award to be dealt with on post-judgment motions. And I would call this the wait and see approach. You can order a holdback for, let's say, 12 months and see what we can accomplish. In this case, we were able to add 11 parties, 7 of whom claim not to be treaty beneficiaries. We were able to add them to this complex 20-year-old case less than a year before it went to trial, and things have worked out relatively smoothly. So I suggest there's no harm that will be done by ordering a holdback subject to post-judgment motions. You can always hear those motions and be convinced at that stage.
Why do you choose 1 year?
I'm sorry?
Why do you choose 1 year, given the pace at which this litigation and the NAME work has proceeded to date?
I'm not actually proposing 12 months. That's not my written submissions. I'm using that as an example, just as an example. But it is a good question. How long should it be? And I have to say, I think in fact, there was evidence before you on the motion. There's no reason to believe that at this stage that Namaygoosisagagun's claim for band status or for recognition as a treaty beneficiary will be completed within 12 months. And what I'm having in mind is that at least in 12 months, we'll be in a better position to know what the time frame might be and what the remaining issues may be. And I think I told you on Friday that Canada's position generally is to attempt as far as possible to allow First Nations to work out differences among themselves. So we would submit that allowing a passage of time for possible resolution following the award is appropriate.
And how do you respond to the plaintiff's proposal?
The plaintiff's proposal, as I understand it, is that nothing should be held back at all for NAME, that 100% of the total award should be split among all 12, assuming that the group of 7 adhere to the treaty. There are still a lot of contingencies in play, therefore, but I suppose we're assuming on the plaintiff's position that those 7 will adhere and all 12 will benefit in the award. And what I would submit here, Your Honor, is that there would be no disadvantage to the 12 First Nations in holding back an award for a period of time to resolve the question of NAME status. There would be no harm or disadvantage to the other 12 First Nations. And if the award is shared among 12 First Nations, when in fact 13 First Nations were and are beneficiaries under the treaty, if NAME's claim is successful, then the other 12 will have effectively been unjustly enriched if the share due to NAME is retained by the 12.
And when you say there's no harm to a holdback, You're presuming there is no harm to a delay in the payment of money. And isn't that what this case is partly about? The
Delay?
harm caused by the delay in receiving due amounts?
But the delay caused by a delay in payment can be remedied by interest.
That's taking a position that interest solves all problems and not getting money.
Well, in my submission, we're not asking for a delay of 170 years. We're asking for a delay of a period of time that may be necessary to enable the parties to work out a resolution here. And if that's unsuccessful, to await the outcome of NAME's claim. And always with the ability of any of the parties to come before you again. And you made that clear in your endorsement and your order granting leave to NAME, that there should be the opportunity for any party to come back before the court post-judgment to seek directions on any amounts ordered to be held back. So we may come to you after the judgment and be able to convince you that we need a certain amount of more time, or we may not. And in that case, you may say, it's been too long. I don't agree that holding the money in a certain account, generating interest is sufficient. You can deal with it then. My submission ultimately is, it doesn't have to be dealt with now, Justice Hennessy. And this case has already shown the benefit sometimes of taking the wait and see approach.
Do you say that that the court could, or do you agree that the court could say assess compensation at, let's say it's $1 million total for all the plaintiffs, $1 million, and then order the Crown to hold back an additional 1%, or not to hold back, for the Crown to put an additional 1% of that $1 million in an account for NAME?
An additional $100,000, or really $10,000, I guess. An additional 1%.
1% of whatever the compensate, the monetary compensation.
So in that case, the additional 1% would not be part of the award of compensation.
Right.
It would be in addition to, in which
In
case,
Canada,
right.
you should have money available if and when you, Canada, come to an agreement with NAME, come to a certain agreement with NAME, that agreement being recognition.
So in my view, Justice Hennessy, that's not any different than what I'm proposing. Because whether you say, here's the total award, tack on an extra 1% and hold it back, or you say, well, really, quite frankly, the total award isn't the total award if it includes an extra 1%. So take the total award and hold back that 1%. I actually think you're arriving at the same resolution, except potentially for this. In the scenario that you're presenting.
Except that 1% for NAME never goes to the group of, to the group of 7 plus group of 5.
That's right.
They're not saying, we may get it, we may not. If that amount is due to us, we have to wait for it. All it says to Canada is, if you want to see them as the same, we hold it separately. We hold an amount for NAME. In fact, Canada probably doesn't hold it. Canada just has it in their consolidated revenue fund or somewhere.
Yeah, the problem that I see with that, Justice Hennessy, is I don't see, as a matter of principle, how that's fair to the other 12 First Nations. If there's a decision on an assessment of compensation that the share of resource revenues that was due to the treaty beneficiaries is X, then that share should be given to the treaty beneficiaries. And if the treaty beneficiaries are the 12, that's who it should be given to.
Except you're telling me not to mathematically calculate what that share is. You're telling me to make it global, or you're proposing that this court make a global assessment.
Yes, but as a matter of principle in my submission, that global settlement is to represent increased annuities which were due to the treaty beneficiaries. And in my submission, as a matter of principle, it's not, it wouldn't be appropriate to, in effect, assess a different amount on the contingency that somebody else might be entitled to it. I see that different conceptually as assessing an award that's due to the treaty beneficiaries, distributing it to those people or those bands whom we know are treaty beneficiaries, holding back a small amount to ensure that we really have covered all the treaty beneficiaries. And as I said, that one of the negative consequences of assessing a separate amount due to a contingent beneficiary is if that contingent beneficiary is found not to be a beneficiary, theoretically, that amount represents a share for treaty beneficiaries. So this is where I'm thinking that as a matter of principle.
Well, that's why I don't want to call it holdback, because it's not holding back.
Yeah.
It's just telling the Crown, you may have additional. It is partly borrowing from the notion of the plaintiffs who say, Canada, figure it out later. It's on you.
I understand your proposal, and I think you have my submission on it, which is that in effect, I don't think that's different than saying X is the total award, pay 99% of it now, hold back 1%, except in the fact that if the 1% isn't paid to NAMA, it will be distributed to the 12. And in my submission, that is a more principled approach. That's all I intend to say on the distribution issue, because the rest of our argument is set out in our written submissions. I'd like then to move to future implementation. And I think what would be most efficient is to take a look at the orders that the plaintiffs are seeking with respect to future implementation as set out in the appendix to their written submissions, and go through them and respond to them point by point. But before we turn to that appendix, I just want to alert the court to paragraph 280 of Canada's written submissions, where we make the point that this court has already provided specific orders regarding the future implementation as part of its stage 1 judgment. And we set out the orders of the court that have already been made regarding future implementation. That's at paragraph 280 of our written submissions. I can go through that if you'd like, with reference to the specific paragraphs in the judgment. There are 6 of them that we have enumerated at paragraph 280. If you have them, then that's fine. Then I will just move on to the appendix in my friend Mr. Schachter's submissions, Appendix A, Section D. The pages are not numbered at that part of the submissions, but you will see that just a few pages in from the very end. And my colleague, Ms. Sang, has them up on the board.
Thank you. Just let me catch up for one moment, please. Thank you.
Beginning at section D of Appendix A, the plaintiffs are asking that the current judgment be amended to add spectrum and other transmissions through the air. You already have our submissions on that point as to why that would be inappropriate. Because spectrum does not meet the definition. Revenues from the regulation of spectrum do not meet the definition of revenues produced by the territory. Moving on then to number 7, the nature of the Crown's discretion over future implementation. The plaintiffs seek a declaration that it is this court and not the Crown's who have the authority to determine what the future annuity augmentation amounts are. This is already the Crown's authority to implement pursuant to paragraph 568 of the Stage 1 decision. The parties will, of course, be guided by the Stage 3 decision. For example, on share. But it is not necessary for this court to make a declaration as to what future annuity augmentations should be, because this was explicitly recognized by this court to be an area within the Crown's not unfettered discretion. In other words, the court has already rendered a decision on this point. The next point, the court shall maintain a supervisory role. My friends seek a declaration that this court should retain jurisdiction to provide further court direction. And in response to this, I say, Justice Hennessy, that the court need not retain jurisdiction. The court has jurisdiction. This is made clear in the judgment, paragraph 3D. That the court has jurisdiction to review the actions of the Crown. And when the Crown exercises discretion, it is not unfettered and it is subject to review. So there's no need for a declaration that the court retain jurisdiction. It has jurisdiction. My friends also ask that the court declare effectively that any disputes about implementation be dealt with on a correctness standard and not as a matter of judicial review. Standard of review is the judges to determine, but the standard of the duty of diligent treaty implementation does not require a correctness review, as we've been through before. In any event, the point being, standard of review is something for the judge faced with the issue to deal with. And I advised earlier that we agree with the plaintiffs that any review of Crown conduct in the future will not be as a matter of administrative judicial review. That's not the appropriate procedure. But the concept of the court reviewing the exercise of the Crown's discretion is already set out in the Stage 1 judgment. In terms of keeping track of and sharing data and holding meetings, the first request is that each Crown be obliged to keep track of data specific to the treaty territory concerning relevant revenues from within the treaty territory and the matching expenses. Justice Hennessy, there is no evidence that this is in fact feasible. So in my submission, the court should not be making such an order in the absence of evidence that it is feasible. We have seen in dealing with Crown revenues for the past that it's possible to extrapolate from provincial figures. So it will be possible for the parties to meet and exchange information without this kind of order. Another part of the request is that each Crown should be ordered to share the data on a timely basis and on request from time to time. And in my submission, this is already covered by the existing judgment, paragraphs 1B and 3A. The court has already advised that the parties are required to periodically engage in a process. That leads us to the concept of meetings. And again, in my submission, paragraph 1B of the judgment already requires periodic engagement there's no need for this court to be any more specific. And in this respect, I recall the decision of the Supreme Court in Manitoba Métis, where the court provided declaratory relief and acknowledged that such declaratory relief would allow extrajudicial consultations. In fact, extrajudicial negotiations with the Crown was how it was phrased in Manitoba Métis at paragraph 137 of Manitoba Métis. In that case, the Supreme Court did not provide specific instructions on what the results of those negotiations should be. It provided the declaration with the confidence that the Crown would abide by it. And in my submission, this court as well should have confidence that the Crown will abide by the declarations that this court has already made and will make. I should say that the court will make. So that addresses the requests of my friends for meetings and the topics of the meetings, which include the request of my friends that the meetings address co-management of the resources into the future. We've already discussed reasons why co-management is not part of the treaty promise. But in addition, I refer to my submission that in Manitoba Métis, the court expected that the parties would determine the parameters of their negotiations. Finally, my friends ask for declarations with respect to, orders with respect to a default formula for sharing. And that unless and until the parties agree otherwise, this court should order that the amount of shareable Crown revenues, resource-based revenues, first of all, should be shared based on Stiglitz and Hutchings methodologies, which I think means using a rents approach, and should equal 100% of the Crown resource-based revenues actually received. This court may make decisions on these sharing issues in its assessment of compensation for the past. In fact, it will have to make such determinations. And these determinations will provide guidance for the parties in the future. But this court cannot direct what the future share should be, because that is not the role of the court. It is the role of the Crown to diligently implement the treaty promise. Some of these further requests regarding 84%, for example, are an attempt to remove Crown discretion in diligently implementing the treaty promise. And I refer you once again back to the finding of this court and approved and repeated by the Ontario Court of Appeal, that the Crown does retain significant discretion in the implementation of the treaty promise, with that discretion not being unfettered and being subject to review against the standard of the Crown. But nevertheless, the Crown must be permitted to exercise its discretion and to make effort to diligently implement the treaty promise.
With respect to future meetings, what do you say to a proposal I made possibly in your overview about a direction that a first meeting should take place within a certain amount of time?
Phrased that way, which I think is different than how I understood it in the overview, I do think that that's a reasonable order that this court could make. That this court ordered that the parties meet within a certain period of time to begin discussions on future implementation, for example.
And what do you say is reasonable?
In terms of the amount of time?
Meet within a certain period of time. What's reasonable and after a decision?
Well, unfortunately, I have to admit that it's quite possible that one party or another will be busy working on appeal materials.
I wasn't thinking that fast.
I was going to suggest 6 months, but then I realized that quite frankly, it's hard to predict what might be underway at that point. So I just really would prefer not to make a.
Well, is 1 year reasonable?
I would think 1 year would be reasonable, yes. And if it turns out there, I mean, with the award, with the order being that the parties shall meet, and if it turns out, just like in Manitoba Métis, where the court did not specify what the parties were to negotiate about in their extrajudicial negotiations, similarly, it may be within 6 months or a year that the parties will say, well, unfortunately, we're not ready to negotiate future implementation because we're still dealing with X, Y, or Z.
Post-judgment motions.
Exactly.
Appeals or.
You know, we have been proceeding on the basis that it's worked very, very smoothly, that the group of 7 First Nations have participated in this trial in the way that they have. But we do have to keep in mind that their interests right now are only contingent, and there will be the necessity of post-judgment motions. There's no doubt about that. And in that respect, the parties will be before the court again, I expect within the year. The final point I would like to make in Canada's submissions, Justice Hennessy, concerns the timing of your anticipated judgment. And I should note that I just want to pull up on the screen the endorsement that you wrote, Justice Hennessy, on Ontario's motion requesting an adjournment of this stage 3 trial pending the appeal in the Supreme Court of Canada. And we've put up on the board and highlighted paragraph 27 to recall that in dealing with that argument on whether or not it was appropriate to adjourn the stage 3 trial, the plaintiffs made the argument. They proposed that whatever risk arises, it can be mitigated by leaving open the possibility to receive both additional evidence and argument until the release of the Supreme Court decision. This is one potential approach to mitigating the risk. The plaintiffs call this the wait and see. And then at paragraph 87.
I'm just going to check. Did I misspeak? Until the release of the Supreme Court decision?
I read that myself and wondered, but I think you can read it, that it does make sense. Leaving open the possibility to receive additional until the release. So hold open that possibility until the decision is released. And once it is released, then you can exercise that possibility.
So it is not, this is not what Ontario asks for.
No, Ontario wanted an adjournment.
No, but it's not what Ontario is asking for today. Ontario says, wait until after the release of the Supreme Court decision. And then allow time for consideration of whether additional evidence or argument should be
My understanding,
proposed.
Justice Hennessy, of what occurred at the motion and the decision that was made, and we'll also turn to paragraph 87, was my understanding of it was the parties acknowledged that we would hear all of the evidence. We would hear all of the evidence because the parties were ready to go. We've been waiting long. Justice, or some of them in particular, were elderly, but that one possibility was that this court would refrain from rendering decision until after the release of the Supreme Court decision, at which point this court could possibly hear additional submissions and possibly additional evidence. And in fact, this court might have decided, I'm going to hear the evidence, but I'm not going to hear the submissions until we hear the Supreme Court decision, until the release of the Supreme Court decision. Now, I'll make this submission. I don't have the record from the argument of the motion, so you can take it for what you want. But certainly I personally recall that there was discussion about the possibility of holding off on even making submissions.
Well, that is consistent with Ontario's current request, but I'm just worried that that's not what paragraph 27 is responsive to.
How do you understand paragraph 27, Justice Henniff, if I might ask?
It says, can be mitigated by leaving open the possibility to receiving additional evidence and argument until the release of the Supreme Court.
I see. And
My question.
after, the alternative language would be after the release, right? I understand. As I said, when I read this again myself, I was a little tripped up by it, but I read it and I thought, I do think that the intention was it would be after the Supreme Court's decision, because that is what would be required to mitigate the risk.
Okay.
And again, let me just pull up paragraph 87, because that sort of is also relevant. Because paragraph 27 appears to me as a consideration of the possibility of this wait and see approach. Paragraph 87 is a little more clear in saying that at the bottom of paragraph 87, the wait and see approach proposed by the plaintiffs is one way to manage the risk, which is more balanced and proportional to the interests at stake. And we have to keep in mind what the risk was. The risk was wasted time, wasted judicial and resources of the parties on the possibility that the Supreme Court may make changes to the judgment that we're operating under. So the first point I want to make is I'm concerned that my friends' plaintiff submissions, that there's nothing holding this court back from rendering its decision, regardless of what's happening in the Supreme Court, is inconsistent with what the plaintiffs argued on Ontario's motion to adjourn. So I have some concern about that, because I think if the argument had been made at the time that it wasn't going to be a wait and see situation, and there would be no possibility of future submissions or even future evidence if needed, the argument may have been different. In fact, it's quite possible that Canada may have made argument on this motion, if that's the way that it was being viewed. But my main concern about the timing issue, Justice Hennessy, is that if you render a decision, you will be functus. And if within a matter of months, the Supreme Court comes down with something even slightly different that might require a slightly different view of one aspect of the case and might require new submissions, not even evidence, I'm concerned that you will be functus and time and resources and effort will have been wasted. And when I balance that risk of you being functus with the potential number of a few months, the answer is clear that you should wait to see what the Supreme Court has to say.
So first of all, you say a few months.
I say a few months because I have in mind, we know that the Supreme Court is hearing these appeals November 7th and 8th. On the very outside, to give the full benefit of the doubt to the Supreme Court, let's say in a worst case scenario, it takes them a year to decide. Let's say we don't have a result from the Supreme Court. I don't think that's consistent with their record in terms of how long it takes to provide a decision, but let's say at the
I
outside.
haven't been shorthanded this long before.
Let's say if it were to take that amount of time. Let's look at what the alternatives would be. If
I just wanted to hear you on a few months. So you think it's possible it would be a year, November?
Yeah, when I said a few months, what I was really talking about the difference in time, because we have to build in time for this court to write a decision as well. So I have in mind, like, it's many months. It could potentially be up to a year if you were to render a decision from the bench. But assuming that you're going to need a number of months yourself to make a decision, I think it's feasible and in fact likely that large parts of your decision could be prepared in the months while we're waiting for the Supreme Court decision.
All right, but let's get back to what you say. So there's some delay. You say it may be a few months, it may be more than a few months, but it's measured in months. And you say that's worth the risk because there might be some small thing that needs to be tweaked. My question to you is, what is the mischief of leaving whatever needs to be fixed to an appeal?
Because although I use the example of some small thing, there's also the possibility that it could be some big thing.
And if it's a big thing, what is the mischief of leaving that?
That we might have to come back to court and go through further evidence. For example, regarding share. I think that when you take a look at the way that the minority dealt with the case in the Ontario Court of Appeal, one of the issues that they differed on was the amount of Crown discretion. And I think share is one example where discretion, the amount of discretion exercise is particularly relevant. It's hard for me to imagine exactly what might come out of it, but I personally can see the possibility that one or more parties may wish to call further evidence on issues pertaining to share. If we have a new decision that says that the graciousness clause doesn't just apply to the individual distributive amount, for example.
Well, what did the Court of Appeal just do on Saugeen? He sent it back to the trial judge.
Yes, it could be, well.
They didn't have to wait. So I'm trying to imagine what the prejudice is. What's the harm of taking that, considering it, take all the time you need, the parties take all the time to consider what they receive and digest from the Supreme Court of Canada. And in the inevitable appeal of this decision, that's one of the grounds or arguments. This is what the Supreme Court of Canada said. It's got to be wrong. It's got to be wrong what happened at the trial level in stage 3. Look at the finding.
So I think that is a possible outcome. The way I'm understanding this now is there is a possible outcome that the change that might be made by the Supreme Court may be something that will simply require it being sent back to the trial judge. There's also the possibility
either by the Supreme Court of Canada or then argued at the Court of Appeal from a stage 3 judgment.
That does make things more complicated to consider that there may be an appeal to the Court of Appeal of the stage 3 judgment, and we may end up with a different interpretation of the treaty coming out of the Supreme Court. So I do acknowledge that.
Wouldn't that be a ground of appeal for the stage 3 judgment?
I think we're talking about two different things. And I do acknowledge there are different routes that ways that it could play out. There are, in some circumstances, things that could be dealt with either on appeal or by sending it back to the trial judge. I do think that it comes back to the point about why take the risk for what I suggest would quite possibly be a matter of months. When you think about the time differential between how long it will take for you to render your decision and how long it will take for us to hear from the Supreme Court, I'm thinking that will be a matter of months. And there's just, that to me is in a cost benefit risk analysis, any risk that the time that's been spent will be deemed to have been wasted is too great.
But is it wasted? Is there wasted time?
Well, I think that I understand.
I'm just trying to get a picture of what it is you're saying might happen. The Supreme Court might make a decision, a different decision on interpretation, might make a different interpretation on share, on Crown discretion. And then it would have to view, I think what you're saying would have to come back to me before I released stage 3. I would have to take into account those findings
And that's, in my submission, what the parties contemplated on this adjournment motion when we discussed, well, any prejudice that can be taken care of by the wait and see approach, see what the Supreme Court says. And if we need to hear additional submissions, we'll hear them then. If we need to hear additional.
But it's one approach.
It is one approach. Yes.
And I hadn't thought about the others at the time. Or perhaps they weren't suggested.
It's difficult, I must admit, for me to imagine this, which scenario might, and to make submissions on what might be the outcome of what the Supreme Court will do. So the best I think I can do is acknowledge, Justice Hennessy, that there are more ways than one that this could play out, in the sense that there could be appeals, there could be something sent back to you so that you wouldn't be functus on a particular issue. But I do think there is a risk that it might not go that way, and that you could be functus, and we will have potentially lost, been unable to salvage the time that's been spent on this trial to date.
If that were a risk, if I thought that was a reasonable risk, that the time spent on stage 3 was wasted, my concern level would rise. But I can't, it's hard for me to imagine that any of this is wasted time. There may be something additional that is required. But my question is, can that not be cured by one of two other paths?
And I think that's a good way to put it. And I think that obviously the court had already concluded, and Canada didn't actually make submissions on the adjournment request, because there was the belief that the time will not be wasted. It can be put to some use, even if the Supreme Court makes changes in some degree, the treaty interpretation, for example. Even if there's a change, the time spent here will not have been wasted. But that was on the basis and the understanding that we will have the opportunity to make further submissions if necessary.
Well,
and
that wasn't a promise.
No,
Oh,
no, it wasn't. I'm sorry, I didn't mean to indicate that it was, but it was something we discussed. It was, a possibility.
Mhm.
Yeah, that was discussed. It was proposed by the plaintiffs, so it's not unreasonable that Canada would have assumed that the plaintiffs advocated for this approach. So I guess what it comes down to is, this time here, it was appropriate, of course, to proceed with his trial, because this time here will not have been wasted. The problem is, we're making the assumption that even if the Supreme Court turns things around, we can still come back to this same judge and, like you said, return it back to the trial judge. We can deal with these factors. And without knowing exactly what kind of decision the Supreme Court might make, and I'm just thinking of a new argument as I think about this, without knowing what kind of decision the Supreme Court might make, I'm not confident to be able to tell this court that there's no risk of a finding that it can't go back to the trial judge because the trial judge is functus. And here's what I just thought of. When you talk about the Nawash case, the new Chippewas and Nawash, that's also a bifurcated proceeding. So arguably, and I must admit, I don't have case law on functus right now, but arguably the court is not functus because it's a bifurcated proceeding and they're going to be hearing on damages, compensation. But this is intended to be the final phase of this trial. I think there's a greater risk that the Supreme Court might not be willing to send it back to the same trial judge.
okay. Well, the court can always send it back to the same trial judge. A higher court can. But the question only is, can the parties bring it back before? That's how functus works. Can the parties bring it back? And even that, there are arguments and nuances. But can a higher court send it back to the trial judge? Happens in criminal cases, doesn't it?
And I regret, Justice Kennedy, quite frankly, I'm not familiar enough with the Functus case law to expand upon my.
I'm not on top of it either.
Perhaps this is a nice telegraph to Council for Ontario about what they might want to address. Subject to any,
We're not nuanced about our telegraphing.
subject to any further questions you may have. That concludes Canada's oral submissions.
Thank you very much. I'm just going to catch up on one thing. Okay. Mr. Greenberg, you're next.
Good afternoon, Justice Hennessy, Council. I think probably just a bit of housekeeping is order first. Can everyone hear me clearly? Justice?
Yes, thank you.
And you hopefully you can see me also on video.
I can see you very well. You're right beside me.
Fantastic. Sorry, but there are delays here, so I apologize in advance. If there's any IT delay. I know I tried to get on camera before to acknowledge your question. Anyway, we are here, we are live. Second matter of housekeeping is we did send the compendium supporting the holdback submissions this morning. I just wanted to check, Justice, if you received a copy of that.
I do have it. I'm just putting it in front of me. Just wait 1 second.
Certainly.
Did my friend send copies to us?
Mr. Greenberg, did you distribute copies to council?
I emailed copies to everyone, all council and the court this morning.
There's a lot of, no, Ontario says yes.
I'm happy to recirculate now. I think we'll also be screen sharing portions of it, but whatever the court prefers.
You might try plaintiffs in Canada. They're all plaintiffs. No, Canada doesn't seem to have it. And the plaintiffs do not have it.
We
We
might,
received it at 9:20 a.m. by email, if that helps. Sure.
we might have received it.
I'm glad I asked housekeeping questions then. I'm just going to resend it now. I can confirm Canada is on a distribution list, so shall I just wait a minute for that to come through, or how should I proceed?
I think there's also some circulation amongst council, sending it around.
I'll give it a moment.
Your Honor, if it helps, we just looked at the file size and it's 32 megabytes. It's possible that it got bounced, but it's on case lines. Okay.
It
So
is
that
on
might be-
case lines.
The size of the file, it seems, was a bit of a problem.
Oh, so if this is a good opportunity to test my screen share. So if we go into the 50-A section E3 is for Namaygoosisagagun, and then you'll see both the holdback submissions and the compendium are both been uploaded there.
How are you doing?
We can proceed.
All right.
We have lots of time to reply. so.
All right. Please go ahead, sir.
Thank you, Justice. Yes, so just to introduce myself, my name is Jeremy Greenberg. I'm legal counsel to Namaygoosisagagun Ojibwe Nation, alternately referred to as the Namaygoosisagagun community, or simply Name. It's perfectly fine to use the shorthand. Joining me, just slightly off camera here, is paralegal Brett Robbins. He's been a silent and diligent recorder and observer of every single day of these proceedings, and joins me today from Toronto, which I'd like to acknowledge is the traditional territory of many nations, including the Mississaugas of the Credit, Anishinaabe, Chippewas, Haudenosaunee, and the Wendat peoples. Today, Toronto remains a gathering place for many First Nations, Inuit and Métis, and I just want to acknowledge this land and acknowledge that as a settler individual that I really take seriously this notion that we reside on lands belonging to the first peoples who were here before us. And on that note, members of the community of Name are observing today. I particularly like to acknowledge Chief Helen Pabola. You've heard from her, at least in affidavit, a bit in this trial. Chief, I understand, has actually just come in. She was on the land for the last week or so, and she's managed to make it back to an internet connection to dial in to observe the proceedings today. So honored to be here to speak on behalf of her community.
Mr. Greenberg, I'm going to do two things. I'm going to ask you to be very conscious of the time.
Yes.
I'm holding the parties to the schedule. And you may recall what you have in time. And secondly, I am going to ask you to be particularly diligent in ensuring that paragraph 2Q of the intervention order is
Yes.
followed.
Okay. Yes.
All right.
100%. We will make the point indeed that our proposal is a way to avoid any concerns over running afoul of paragraph 2. So we intend to address 3 issues in our 30 minutes today. So the first is we'll provide an overview of Name's proposal, which is simply this, and I think it's a relatively small proposal, and that is that holdback of some amount on behalf of Name can be best addressed by a post-judgment motion where limited evidence is led on its population and potential percentage allocation of the compensation can be led without running afoul of the restrictions imposed at stage 3. The second issue I will address is why this proposal will bring necessary clarity to the question of Name's contingent interest. Again, partly or indeed largely because during stage 3, it was blocked from making any submissions departing from the other plaintiffs on distribution. And I'll be making the point that I think that today what we find is the plaintiffs in effect leveraging the restrictions imposed on Name to simply propose excluding it because Name is barred from disagreeing with them. So that is the second issue I'll be addressing. And then the third one, and it's linked in a sense to what I just said, is putting meaningful effect to these concepts of reconciliation and the honor of the crown that have been discussed throughout the last 9 months, the last 20 years of this case, and thinking what that means for a very small community, a community that is just asking for a very small percentage of the final treaty compensation to be set aside for it in the interests of reconciliation and moving forward on this treaty relationship, if and when it's recognized as a treaty beneficiary. So to begin, I actually want to start by addressing an issue or a question, Justice, that you posed yesterday, which is the meaning of the word sacred. So I took this question back to the community, had a very interesting conversation, and they asked me to share a couple of points. And I'm going to apologize to them now. I am paraphrasing much more meaningful words that were said by Namaygoosisagagun. But the bottom line for Name is that for that community, sacred means being able to live on their land, live off of their land, to make use of it, and live for their land. So they take it as a sacred obligation to guard and to take care of this land, which has been part of their generations, for part of their community for generations preceding, And they're seriously invested in its sustainability and its future for the many generations to come. And I think as we get into the heart of the submissions, that it helps to keep in mind that that sacred trust, which NAME takes very seriously and is taking upon itself, they feel as if that's been called into question and in a sense delegitimized by the submissions being made by the other parties today. So the mere fact that an Indian Act, a colonial statutory process on band status hasn't resolved yet, really shouldn't give license to council to attack the legitimacy of NAME as a First Nation, and indeed as a potential treaty beneficiary. And I just worry that issues that were already addressed back when council opposed NAME's intervention more than a year ago are being brought back up again to try to suggest that somehow it's too complicated to deal with the fact that NAME is locked into this government process, federal government process to try to get recognized for band status. On that note, let's turn to item 1 in my submissions, which is what I'm calling the very small proposal. And this begins at paragraph 10 of our submissions, if you're following along. I'd asked Mr. Robbins to pull up the draft order, which is found at tab 1 of the our compendium of materials. So I'll just give that a moment to come up. Well, I can start describing it already. So we've already heard from the group of 7 that their proposal is that 40.49% of the total treaty award should be held back for the group of 7 as contingent beneficiaries. And the group of 7 have maintained all along that they're not beneficiaries under the treaty, but to the extent that they one day become recognized and they adhere to it, they would then ask for that 40.49% to be held back. Mr. Robbins, can you scroll down to the, yes, here we go, perfect. Now let's look at what NAME is proposing. It's saying, first of all, that today, there is a lack of clarity around what its holdback might look like. Mr. Schachter has, I think, correctly pointed out that there really isn't tested evidence on the record of what NAME's population will be if and when it's recognized under the treaty. And indeed, Canada's proposal of 1% doesn't really seem to be founded in anything other than respectfully, I think, maybe Canada wishing to hold back to 1% of the total award, continuing to use it until NAME can come claim it at some future date. I mean, no disrespect to Canada, I just mean in terms of the mechanism, I think it's important that whatever the holdback is, it should really be separate, court supervised, the same way that any mechanism for the group of 7 would be. So to solve this issue, how do we solve the question of NAME's allocation? Allow for a post-judgment motion, which would bring specificity to the amount to be set aside, and limited evidence without violating the terms of the order, paragraph 2, that would allow the chief to explain to the court what the population looks like in 2023, 2024, as it approaches recognition as a band, and as members transfer their membership from all over. So not just Robinson Treaty area, but Treaty 9 members, Treaty 5 members, the rest of that. And the only other point I would say about that is that we would suggest that no time limit be put on the holdback, maybe provision that it can be revisited at every 12 months or something like that. But because NAME is relying on this external process, it is subject to bureaucratic reviews. It's a very active process, by the way, Justice. So I know you asked about whether it's been paused, far from it. There have been interviews ongoing with elders. There's about 1,000 pages of materials or more that are being reviewed by a department within CERNAC. So all of this is happening now. I wish I could say it's going to be done by the time that this decision is issued in this case. It's hard to predict, but in any event, if we just set this whole question to be dealt with after stage 3, I think that takes us, that basically resolves this ambiguity around the population and what that percentage would look like.
Mr. Greenberg,
oh, yes.
I have a question, sir.
Yes, Justice.
In your proposal just made now, what is the difference between that and paragraph 3 of the intervention order?
And are we able to pull up paragraph 3? So I think paragraph 3 is the reference to a post stage 3 motion, if I recall correctly.
It says any party or intervener may bring a motion following stage 3. Is that a limit to someone other than NAME?
No,
May
no,
bring a
absolutely.
motion.
So this is in line with that order. That's the point, is that it's leveraging the provision made all the way back in, I think it was May 2022, to allow.
Is it, what is different? And why do you need anything other than paragraph 3?
So what's different is that we don't know what the holdback amount would be. So in the group of sevens case, it's easy. I mean, if this court accepts that it's 40.49%, it's set aside in the stage 3 judgment. And then there's a post-judgment motion to release that amount. And maybe if they're never adhered to the treaty, then maybe Red Rock and the other plaintiffs make a motion to release it to themselves. I think in Name's case, the concern, which is a fair concern, is we don't have a percentage on the record because Name was blocked from making submissions on that very issue. And I would add to that, Justice, I think you can take down the screen share. I would add to that there's nothing novel about this proposal. I mean, I won't belabor the point, but obviously the idea of holding back some funds is common. It's common in the class actions context. We talked about that at paragraph 9 of our submissions. Treaty settlements regularly, almost always eventually results in some sort of trust fund being set up. And really the only point I would make on that, and you can see these cases at tabs 23 and 24 is the class action settlement, and then tab 25 just gives an example of the treaty trust. And the only point to make, and Canada's made this point as well, I don't think there's anything really controversial about the mechanism itself. And I think that if this court permits it, it could be the same as mechanism as whatever is used for the group of 7.
And Mr. Greenberg, you're saying you want the parameters of a post-judgment motion to be wide enough to hear, in your words, what you were blocked from arguing at stage 3.
Yes, and I think
So
there
is this an appeal of that motion?
Not in the least, Justice. But our proposal is that there is a way to do this with a simple declaration in the stage 3 decision itself, inviting a post-decision motion from NAME, and then some very limited order, really restrained. We're not talking about a big relitigation of what the distribution should be. All it will be is what NAME's population will look like once its membership is transferred, and really how that 2017 list, the petition list that came before the court, is really an outdated picture. And respectfully, I think there's a concern here that the 1% from Canada proposal may have been based on that 2017 list, but it arose in such a different context. It was a petition to show a minister that there was some interest. It was never supposed to be a definitive membership list.
And I'm just looking at the transcript. Did I miss a word? Did you say a declaration of a stay?
No, a declaration that a setback or a set aside or a holdback would be addressed on a post-decision motion. So I think the language that is used by the group of 7 in their submissions is a declaration regarding the share of any compensation to which the group is contingently entitled, and in their case, based on the formula contained in the intervention order. And then once the treaty status is resolved, any of the parties may bring a motion for the disbursement. So the qualifier for NAME is, it would be dangerous to just set that rate now as 1%. So we would suggest setting it as likely within a range of 1 to 5%, and then just address it and finalize that number of a post stage 3 motion. And on that note, Justice Hennessy, I mentioned, these are issues that we've talked about before. This court addressed these questions to an extent in its original decision, inviting NAME to participate. So as you may recall, NAME entered this case because this court invited interventions by First Nations claiming to be treaty beneficiaries. it was actually quite content to enter under representation order with the other plaintiffs, but because of the opposition, unfortunately, it was contested. And I want to briefly quote from the decision adding Neme to this case. So I don't think I risk running afoul of anything because I'm quoting this court's words on Name's role in the case. So this is tab 5 of our compendium. Mr. Robbins, maybe you can pull it up as I speak. So in Restore 2022 ONSC 1294, this court writes, paragraph 2, the plaintiff's fundamental objection to Name's intervention is rooted in the fact that at this point there is no cognizable collective recognized as a band. Nevertheless, the history of its efforts to achieve band status is not contradicted. Against the backdrop of this effort, Name seeks to protect their contingent interest by way of intervention. And it goes on to describe how that interest is different from the other bands. So its first contingency is on recognition as a band under the Indian Act, it's the external process, which creates a possible interest. And then this is the key statement. And so we are at,
Can you tell me the
paragraph 2.
page? Can you tell me the page? Can you please tell me the page number in your compendium? Oh, I've now found
Yes, yes, so it's E. It's the wrong quote.
3. I found it. E3-50 and following.
Yes, yes. So there's a statement from this court, and I'm not sure why it's not showing on the screen, but the statement is, this contingency, the question of its band status, may not be determined before the trial on this matter either begins or ends. And that is why, that is why we're here today. So what happened was, this court acknowledged it may not be resolved, so let's make a provision just like the group of 7. Some provision can be held, some amount can be set aside. NAME can seek to release those funds later after the stage 3 decision. And this is important. So it's the same decision. If you can scroll down to paragraph 9. Again, so responding to issues raised, so the plaintiffs maintain their position. Are you able to zoom in a little bit? The plaintiffs maintain their position that NAME's unrecognized status remains a significant barrier to their intervention. The rights at issue in this proceeding are collective rights to the annuity, not individual rights. The plaintiffs submit NAME lacks any present interest. But then paragraph 19, you can scroll down. Justice, this is this court's order, adding it. Although NAME may not be at this time recognized as a band within the treaty territory, they have a contingent interest as a collective. That is a point of judicial comment, adding NAME into this case. And then paragraph 21, although adding NAME is not without significant risks of delay and overcomplication, on the other hand, its contingent collective interest cannot be considered or protected without allowing their participation as an intervener in this proceeding. And we've mentioned already, of course, there are restrictions on that. We are not asking this court to determine whether it has a band status. We are not asking to determine whether it's a treaty beneficiary. All we're saying is that in line with this ruling of May 2022, NAME's contingent interest should continue to be protected in the form of some holdback, exactly as provided for in paragraph 3 of the intervention order. And I think on that point, Mr. Robbins, you can take down the screen share. On that point, that brings me to the second issue here, which is how do we deal with this complexity, which admittedly is a moderate degree of complexity. As stated at the outset, there isn't necessarily tested evidence on the record about what NAME's population looks like, and certainly not what it will look like once members transfer their membership to Namaygoosisagagun. If a post-judgment motion is permitted, it can do a number of things. First of all, as suggested, it can avoid any risks of running afoul of the conditions currently imposed in stage 3 about departing on distribution. It can be very narrowly limited to this population question about, we've referred to it as the Namaygoosisagagun diaspora. So this notion that as we speak today, there are conversations happening among individuals who wish to register with NAME, but aren't able to do so until that process is resolved. Again, not putting an invitation here, I'm aware of Mr. Schachter's comments, but just pointing out that this is all sort of a very live process that's happening. And the other thing that this proposal does is it gives us a third route when the only two options before this court are respectfully bad and self-interested options. So Canada has spoken about holding 1%. Canada would control it. I think we should be deeply concerned about a treaty claim where Canada is purporting to just continue using compensation funds as it sees fit, and then releasing that at a later date and requiring the First Nation to come to it to get those funds released. So I made this point at the start, it should be in a trust or some court supervised mechanism. And respectfully, and I don't even think this is controversial what I'm saying, the other plaintiff's proposal is obviously self-interested. So because NAME couldn't make submissions on its population and potential allocation, we see in the Red Rock materials, we've heard from Mr. Schachter, Mr. Bass, and over the course of the past week, that they're just saying NAME should be left out. You know, 100% of the award should go to NAME, and if it's ever recognized as an RST beneficiary, it can, relitigate the entire Robinson annuities litigation? I mean, if we think about these principles of reconciliation, if we think about commitments to the sharing of the treaty award, again, and I take this as earnest, right? I believe Canada and I believe the other plaintiffs when they talk about these fundamental Anishinaabe principles of sharing and about the shared goal of reconciliation. If we're to take that seriously, does it make sense to just exclude NAME here at the 11th hour of this case and then ask it to mount a new case on its own? We saw 12 nations band together to hire extensive expert evidence. Nobel Prize winning economists came to speak to this court over the past 10 months. I mean, as a matter of judicial economy, it would be troublesome to ask NAME to have to relitigate this case when it's already been recognized that it has this contingent claim within this court's orders, but also just as a matter of reconciliation and the honor of the crown. Now, this is not to say, Justice, that the 2017 petition doesn't reveal some important details. And I want to emphasize this point because if I understand Mr. Schachter's proposal correctly, he's suggesting that those NAME members who are currently registered within the Robinson Treaty area will be covered in effect by the judgment. To an extent, that's true.
Can you tell me, what is the 2017 petition? Is that NAME's?
Yes. So this was a petition that was prepared for the Minister of Crown Indigenous Relations. It was to demonstrate that there is interest of individuals to transfer their existing memberships. That number we've heard before, it's the 94 people who signed the petition. It was actually 149 people who put their names down, but in the end it was 94 who were able to sign. And of those 94 people, only a minority of them, 36, are actually within Robinson Treaty beneficiary nations. So what does that mean? Just looking at that figure, which we're not saying is the final figure, quite the opposite, but a majority of NAME membership is in Treaty 3, Treaty 5, Treaty 9. It's not in the Robinson Treaty area. And this court has commented on the fact that this is a collective entitlement and has said NAME is entitled to participate as its own collectivity precisely because the membership of its interest isn't meaningfully represented by the other parties. So in requesting this NAME specific holdback, what we're saying is, yes, for now, members within Robinson Treaty annuity nations, of course, they'll be entitled to their annuities, they'll be claiming it. But for all the rest of them, at least that some funds should be set aside pending NAME being recognized as a beneficiary. And indeed, once the collective of NAME, if recognized as a treaty beneficiary, that there is already funds in place that can address that. And on that note, Justice, you posed an interesting question to Canada just maybe an hour ago about what that holdback can look like, whether it's a reduction of the global award or if it can be over and above. I think that's an interesting idea. I mean, right now, 100% of the treaty award, if we go with the Red Rock and Group of Seven proposal, just goes to those 12 First Nations. NAMI is suggesting that instead of all 100% being paid out right away, we deal with this post-judgment motion. We figure out NAMI's allocation, maybe it's 2%. So we reduce it, so 2% goes to NAMI, and then 98% is then divided up between the remaining. Again, I said at the start, it is a very, very small proposal, and it's a lot different from the 40-odd% that's being proposed by nations who don't even claim that they're under the treaty. That said, I think the idea of going over and above the treaty, the global award, is very interesting. So it may be that in the end, to simplify things, there is an award that is 100% split between the Red Rock, White Sand, and then Group of Seven plaintiffs. And then a post-judgment motion solves what the percentage over and above that would be for NAME, and then that's put into some kind of trust mechanism. I think I'm curious to hear Mr. Schachter's comments on this. I expect that might be more welcome to the other plaintiffs if the main award goes to them and there's something over and above set aside. But in any event, all NAME is asking for is that we figure out what that number is on a post stage 3 motion. And really, turning now to the final section of my submissions, which is this notion of taking reconciliation seriously. I'd ask this court, and indeed I'd ask the other parties to consider the prejudice to the parties in different outcomes. So in one scenario, some amount is determined for NAME on a post-judgment motion. This amount is held in trust. It's 2%, it's 5%, whatever it is. It sits there, gathers interest. We don't rely just on interest, but there's provision made for it, just like in paragraph 3 of the motion of the order, that after the question of its beneficiary eligibility is resolved, NAME can bring a motion for release of those funds. And of course, if it turns out it's not part of the treaty area, or if it's taking a really, really long time to go wend its way through the federal crown process, that the issue be revisited. And of course, and this is in our draft order, I think it would be fair to say that if another party brought a motion to release those funds to them, because it's taking so long, whatever taking so long means, then NAME would be given the opportunity to respond to that. But in any event, and I said this at the start, I would really request, given that we're relying on this external process over which the court has no control, that there not be a set time limit. It shouldn't be that in 24 months that money just gets released. That creates a huge problem. You have unjust enrichment, as Ms. Evans pointed out, of the other plaintiffs. And you have this real concern that NAME is then forced to relitigate the entire annuities litigation. At the same time, and I said this already, but the principles of judicial economy certainly would suggest that simply setting aside a very, very small percentage and then either releasing it to NAME or eventually releasing it to the other parties really is a preferable option to having those funds just get all released at once and then forcing NAME to, in effect, go back to the drawing board on this case. Now, as to the question or as to putting meaning to these principles of reconciliation, term we've heard bandied about many times, and very similar judgments quoted many, many times in front of Your Honor. I think it's worth going back to what this court said. So Justice Hennessy, what you said in your stage 1 decision about how we should view reconciliation in this case. So it's recreated at tab 14 of our compendium. I don't think we need to pull it up. I think we know these quotes by now. But paragraph 337 of the stage 1 judgment, to achieve a purposive interpretation, the court must keep in mind the purpose of the augmentation clause, the purpose of the treaty as a whole, and the purpose of all treaties. That is, the reconciliation of the pre-existence of Indigenous sovereignty with assumed Crown sovereignty. Paragraph 478. And I know, at the risk of quoting you at yourself, Justice Hennessy, I think hearing these words again and thinking about NAME as this small community just trying to ensure its rights aren't overlooked. The honor of the Crown is a foundational principle of Aboriginal law governing the relationship between the Crown and Indigenous peoples. Its underlying purpose is the reconciliation of Crown and Indigenous interests. And in our case, so as we sit here today, the duty of honor applies in the making, interpretation, and implementation of the Robinson Treaties. And of course, the Court of Appeal echoes this in its decision. We've heard this before, paragraph 113 of the Court of Appeal's decision. The controlling question in all situations is what is required to maintain the honor of the Crown and effect reconciliation. And I would add to that, and we've cited a few cases about using reconciliation as an interpretive and a contextual tool. I'm going to take us directly to the Indigenous Police Chiefs of Ontario case. It's tab 22 of our compendium. Mr. Robbins will pull it off and I'll read the quote to you as he's getting it up. So it's paragraph 140. This is a federal court injunction decision. So there was a motion for release of funds to a group of First Nations police services pending an ongoing, oh, sorry, Justice.
Can you please tell me the page number in the compendium?
It is Echo 3189.
Thank you.
And we're going to actually scroll down all the way to paragraph 140. So this is a perfect example of an IT problem. This is going to take us, okay, so here we go. So this 140 is excerpted. It's E3190 in the bottom right corner. So it's talking about the test for injunctive relief. And as I read this to this court, I would ask, just replace the phrase test for injunctive relief for motion for holdback of treaty funds. So the test for injunctive relief requires a contextual analysis. Therefore, the particular obligations to be borne by the Crown when dealing with First Nations are necessarily part of the circumstances the court must consider. To echo Associate Chief Justice Gagne, it's an earlier federal court decision, and Pequawki-Molnitz, it is well known that judicial debates raising issues affecting First Nations must take into account the Indigenous perspective, as well as the historic, social, and legal context. Therefore, when reconciliation and the honor of the Crown are involved, the injunction test has to be viewed through the lens of these guiding principles. And if we can just scroll up for one moment. So we see this phrase, the Indigenous perspective, historical, social context. Respectfully, Justice, what's been missing, understandably missing, is the perspective of Namaygoosisagagun. It has been very careful, and I hope I've been careful today, to not run afoul of the restrictions imposed on its participation. It has remained silent, as other plaintiffs have suggested that it just doesn't get any holdback percentage of the final treaty award whatsoever. And that brings us to today. And so all we're saying, and I realize I'm coming up almost on the 30-minute mark here, is that if we take these commitments seriously, which I really think we do, I think everyone does, is it appropriate to leave Name effectively out in the cold, to exclude it because it's waiting on the outcome of an external bureaucratic process? It's a process that's moving as fast as it can. It's got a federal court judge overseeing it, but nevertheless, should we leave it out in the cold simply because that process hasn't resolved? Or do we do the very, very small thing? And I think we can take it down now just to conclude. The very, very small proposal, which is if we're going to be setting aside 40.49% for the group of 7, let's allow for the possibility that Name may also be one day entitled to compensation. Let's admit it's going to be a very, very small percentage. And then let's just hear that very, very limited evidence. We will make sure that it doesn't run afoul of the order of the court. And we'll just get in, what Name looks like in 2024, if and when it receives ban status, and if and when it, well, I should say when, it approaches the Crown to get recognized as a distinct treaty beneficiary, which it has always maintained from the very, very start of this case. And on that note, Justice, I think that if we're looking sort of ahead at the future of this case, and if we're looking at this gap that is about to come up, I think it also bears in mind that what Name is asking isn't really even going to cause any sort of delay or undue prejudice, as has been suggested. There's obviously going to be a lot of work done on setting up and setting the definition for the group of 7 holdback. I mean, as far as I can tell, the group of 7 hasn't actually proposed what that looks like yet. So that's going to require all sorts of post decision motions. As Ms. Penavins pointed out, we are waiting on a Supreme Court judgment. There is the unfortunate likelihood, far be it from me to challenge your decisions, Justice Hennessy, but this decision may also wind up appealed, and there may be requests to stay implementation of this decision. But the point is that in and amongst all of this, all of these aspects that are going to have to be dealt with, is it really such a harm to the other parties, as they've suggested? Is it really so unnecessarily complicated to just let NAME bring in this little bit of evidence, what its population is, what its contingent claim would be, and then if at the end of the day, you know, it's not recognized or the holdback is too large, then 1 or 2% of the treaty award, which was held back, it's gathered interest, and then it goes off to the other First Nations anyway. We're talking very, very small figures here. So at the risk of repeating this quotation from the Court of Appeal, I just say it again, it's the controlling question in all situations. What is required to maintain the honor of the Crown and to effect reconciliation? And sorry, Justice Hensley. Did you say something?
No.
Oh,
I
we
did
have
not.
an audio glitch. There's a delay here. Sorry.
There's nothing from the court.
Okay, sorry. I heard sounds and then it froze. Sorry, Justice. Yes. So just to conclude on this note about reconciliation, about thinking about this, we've also included in our case a very recent decision, not necessarily widely reported. That's Iskatawa-Zagagun First Nation and Winnipeg. It's tab 21 of our compendium. This needs to be the eternal battle of what case line's number it is. Mr. Robbins, would you be able to assist me? So as you pull it, at any rate, it's tab 21 of the compendium. It's 2021 ONSC 1209. And in a very different context, it's a claim for compensation for the taking of water by the city of Winnipeg. The court says, the honor of the Crown is a constitutional principle. It's an important word, constitutional principle. It is, I said, it sits above, you can call it underlined. It is a constitutional principle enshrined in Section 35 of the Constitution, recognizing and affirming existing Aboriginal and treaty rights. So I think it's fair to say that the existence of Name itself as a First Nation isn't contested. It's whether it's going to get recognized under the Indian Act. So recognizing and affirming, broadly speaking, Aboriginal treaty rights, which NAMA has always asserted that it has. The honor of the Crown is a fundamental concept that exists as a source of obligations independent of treaty obligations and fiduciary duties. The court goes on to say, the honor of the Crown infuses the processes of treaty making and treaty interpretation, and in making and applying treaties. And we find similar comments in Yahe. I'm not going to pull it up. We've heard it at the Blueberry River Nation. We've heard it quoted already about a week ago. But paragraph 1869 of that decision, it's tab 20, pardon me, of our materials. In accordance with the purposive approach to construing Section 35, remedies relating to Aboriginal and treaty rights, and I'll pause, such as the remedy Name is seeking, remedies relating to Aboriginal and treaty rights should be sensitive to and advance the distinct purposes of Aboriginal rights, including the importance of treaty making, pardon me, as an honorable form of reconciliation. So if I can just wrap up my submissions with a summary of effectively of what NAMI is proposing, to limit the amount of controversy, to avoid running afoul of paragraph 3 of its intervention order. All we're asking is, bearing in mind recognition it has a potential claim, that the stage 2 decision acknowledges that potentiality, call it a contingent interest, that the stage 3 decision invites or authorizes a post-judgment motion from NAME. And I imagine there will be some provision in there inviting a post-stage 3 motion from the group of 7. So I'll leave it to Justice Hennessy, Your Honor, but I assume similar language can be used. But effectively saying NAMI should be allowed to bring in this limited evidence on its population. And then once that's actually addressed, then that would result in an order setting aside that percentage, 1 to 5% of the funds. And then it would be held in trust, not by Canada, but in trust until such time as NAMI's claim to being a beneficiary is resolved. And I know, Justice, you did ask whether band status determines whether it's a beneficiary. That's not the case. I mean, Mr. Gass pointed this out a few days ago. So once status is recognized, that what Justice you called was the first contingency in the original order, that will then be the opportunity for NAMI to go to Canada, to go to the Crown and say, we now want to be recognized as a treaty beneficiary, which, and I think it's a matter of historical record, is something that has happened for many of the plaintiffs in this case. Not all of the plaintiffs, to our understanding of the historical record, were recognized as distinct beneficiaries in 1850. Many of them were, I think the term used is distinguished from existing treaty beneficiaries, allocated their own reserve land. This is exactly what NAMI is trying to do. External to these processes, not asking this court to rule on that. It is trying to do what other parties had the benefit of doing 50, 60 years ago, get recognized, get its own reserve allocation, recognized under the Indian Act, which is an unfortunate colonial legacy, but it's there, and then use that statutory recognition to then petition to be recognized under the treaty. And then, of course, once that happens, to then bring a motion to this court to release the funds that hopefully would have been held back, just as the Group 7 award presumably is also going to be held back until they can bring such a petition to this court.
I have a question, sir.
Yes.
You seek an order that there be a holdback of 1 to 5%.
So
Is that you're asking? Just let me finish, please. Is that asking the court to decide some percentage between 1 and 5%?
Yes, the intention would be that the court rules in the percentage after hearing this limited population evidence.
No, you seek it. I thought you seek an order from stage 3 that there be an amount held in trust.
With that amount to be determined on a post-stage 3 motion.
Thank you.
Yes, and the reason for doing that.
So the order you seek from stage 3 is that the amount will be somewhere between 1 and 5%, such amount to be determined on a post-judgment motion.
Exactly, and that's exactly you'll find. I think it's the very first clause of the draft order that was provided with our submissions. It's exactly that. Well, we recognize it'll be some amount in that order, and then that order acknowledges and invites a post-stage 3 motion that will just finalize what the amount is, whatever it is, between 1 and 5%.
Thank you.
Justice, I'm cognizant of the time. Barring any further questions from this court, I think I've addressed all the issues you sought to raise. I think the only other point that I would make is that whatever this court is looking at doing for the Group of 7, we want to be as friendly and helpful as we can. We want to complicate this the least. So whatever that winds up looking like, I think our client would be content to have a very similar mechanism used for its holdback with, and I said this before, but just ensuring that Canada or the Crown isn't allowed to just hold on to those funds and use it as it sees fit.
Thank you.
Thank you, Justice Hennessy.
Thank you. Okay, thank you very much. Is it time for a break? And then we'll hear from Ontario. Thank you. All right, we'll take that break. I'll stay here.
We're all right.
This court is stood down for 15 minutes.
We're all right.
This court is resumed. Please be seated.
afternoon, Ms. Barclay.
Good afternoon, Justice Hennessy.
What should I have in front of me?
I would be happy to tell you, Your Honor. You should have our main submissions. You should also have our reply submissions. Those have previously, as I'm sure you're aware, been distributed and they're on case lines. My friends all have those copies. In addition, just a short few moments ago, we passed around a compendia that I will be referring to during my submissions. It's marked as volume 1. I might suggest that we mark it as the next lettered exhibit. Speaking with my friends, we think that might be MM.
The clerk just reminded me that we didn't make Mr. Greenberg's compendium an exhibit. So why don't we do that, the electronic version? Unless anyone's got a problem with that.
Not an exhibit in the cause, so it's just for the assistance of the court, so that's fine.
Oh. Does anybody else have anything? Oh, Mr. Greenberg's here.
No, Justice, I think I heard you just asking whether the compendium can be entered. That's fine.
I'm sure what's fine.
Sorry, if I heard, and it may just be the audio of this end, were you asking, Justice, if the compendium should be entered as an exhibit?
I did suggest that, and Mr. Schachter reminded me that it's not an exhibit in the cause. It should just be received as for the assistance of the court.
Okay. Whatever.
content.
That's fine, Justice. Thank you.
Thank you. Okay. Just. Okay. So you're asking this be made exhibit MM? Is that, Madam Clerk, is that what you say?
Okay.
Done. Exhibit MM.
Okay, thank you.
And this is on, when it's volume 1, do you call, you give it a certain topic?
That's right. It's not marked, so it's, we could call it also the Crown allocation volume, if that would be of assistance to identify.
Thank you. We'll mark exhibit MM then as Ontario's compendium Crown allocation.
That's right. What we've also handed to Your Honor and distributed to my friends as well is an outline of oral argument. And I might just have you refer to it for a short moment or two so as to orient you as to how the Ontario team proposes to proceed with our closing submissions.
Thank you.
Obviously, I'm on my feet. I will be doing the introduction. I suspect I will be quite brief. We don't intend to take much time doing a windup. My role is to take you through the majority of Ontario's submissions respecting Crown allocation. And that's largely in response, of course, to Canada's cross-claim against Ontario. I say majority because there's a couple of issues, one with respect to nominal values in particular, and one with respect to direct liability that my colleagues, Mr. Marcello and Mr. Rankin, will respectively refer to in their submissions. I suspect that the Crown allocation portion of our closing submissions is going to take a full day. And by that, I mean, given the time right now at 3:45, I will be quite surprised if I finish before the end of the day tomorrow. My friends, or my colleagues rather, will pick up where I sit down with economics first. Mr. Huang will start off. You'll see here on our outline at 3 that he is going to address the calculation of nominal NCRRs. When he finishes, Mr. Marcello will take you through quantification, economic rents, present value, and the sharing for the different models that have been presented. Mr. Rankin will conclude with looking at remedies. He'll be addressing remedial principles And given your honor's questions to some of my friends earlier this week already, I'd like to flag there for you that within those submissions, he has some comments that he will address respecting the nature of treaties and including the Supreme Court of Canada's language of sacredness.
Thank you.
Mr. Rankin will also make submissions respecting the duties at issue, including the duty to augment, the duty to engage in the process. He'll address future implementation, and then he'll conclude with the timing of the judgment.
Thank you.
Now, this is all to say that, as I said, I certainly hope that I will finish by end of day tomorrow.
Do your best.
I shall. I'm sure my colleagues will do their best to be guided by your direction to keep within our original time frame as well. I might make the observation that when we discussed the timetable, the Crown was to have this week, and the division was to be about 2.5 days for Canada and 2.5 days for Ontario. So I do hope that we will finish by the end of the week. I don't have half a day right now. We might, as a team, collectively bleed into a bit of Monday. I want to highlight that for you now. We will try not to, but even keeping within the original timetable, as you've asked us to, that's what we had prepared, 2.5 days. We will try our best. May I begin?
Please do.
So, as noted, my intention is to spend quite a bit of time on Crown allocation. That dispute, of course, boils down to who is liable for any increased annuities that you may find in your judgment to be owing to the plaintiffs. You've heard, of course, that it's Ontario's position that that liability rests with Canada alone. Now, I've listened to Canada's submissions, and of course, I've read the materials, and I suggest to you that what they're submitting, in effect, is that this court's decision in 2018 should be transported back in time, and that it should be superimposed on events between 1895 and 1900, so as to A, undermine not one, but 2 decisions of the Supreme Court of Canada and 1 of the Judicial Committee of the Privy Council. 2, to relitigate the Section 109 issues, which we say have been found already by those courts and are binding determinations. 3, to further undo a binding final award of the statutory arbitrators, award number 15, which we will make submissions was made on consent with full knowledge that there was a risk of annuity payments possibly going beyond $4. That award was not appealed. It was plainly, we will submit to you and take you through why it was within the jurisdiction of the arbitrators. And finally, they ask that you undo the final settlement of accounts, essentially, that had taken the Dominion in Ontario and Quebec, the new provinces of Ontario and Quebec, approximately 35 years after July the 1st, 1867, to finally and conclusively settle. And it's our submission to you that you should not do any of this. Canada's assertion that it is a minor partner in the Robinson Superior Treaty and respecting the payment of augmented annuities is just quite simply incorrect. Now, it is important, I believe, to say that Ontario does not say that it is a stranger to this treaty. I heard my friend Mr. Schachter correctly last week. I think he suggested that that was our position. It's not our position. It's never been our position. We do not dispute now, nor does Ontario ever dispute that it has obligations and responsibilities under the Robinson Superior Treaty. These are varied, but respecting the ones at issue in this case, the narrow issues in this case, that is those under the augmentation clause. It has been Ontario's consistent position since at least the 1870s that its role is to provide information when requested to facilitate Canada's obligation to engage in a process with the Anishinaabe in order to determine if the condition precedent in the augmentation clause was triggered, what should be shared, and ultimately to pay any increase determined to be owing. Canada is in fact the majority treaty partner when it comes to paying and administering annuity payments. Your Honor, my submissions will develop 2 points. The first is that Award 15 makes Canada alone liable. With respect to the allocation dispute as between the Crowns, Award 15 is the final award of the statutory arbitrators, and it fully releases Ontario and Quebec from responsibility between the Crowns for any further augmented annuity payments. I'm going to spend quite a bit of time on Award 15. The second point that I'll develop, however, is about the Constitution. We say that it also makes Canada alone liable. Under the Constitution, Canada is the emanation of the Crown responsible for direct payment of any increased annuities. The relevant provisions of the Constitution, what I'll refer to as the BNA Act 1867, simply because that's what it was called at the time, and you'll see that vernacular in the documents. Those provisions make it so, as do, as I've alluded to, several binding judicial determinations that considered those provisions. So in the time that I have today, I will start with Award 15. I will not get through Award 15, I don't think. I'm happy to take your Honor's direction as to when we stop. Please just pull the door, bring out the hook, let me know. So I've said that Award 15 is a final court order. It contains a full and final release of Canada's claims against Ontario and Quebec for augmented annuities under the treaty. I'll come back to that point about Canada's claims, but I might flag it now because, of course, the issue that was before them at the time was dividing the accounts for excess debt and how Canada could make a claim for indemnification against the provinces for any debt in excess of the debt ceiling. Now, those are constitutional provisions. I don't want to get ahead of myself. So let me stay with Award 15.
Okay, and let me flag what I see as the debate, and I'm always happy if you tell me I've got it wrong in any way or I haven't encapsulated. But my understanding of the debate on this point is this assertion that Ontario makes that Canada entered into the consent award and that the awards take into account that Canada had, as you say, full knowledge of the risk of an obligation to pay annuities beyond $4.
I'm sorry, did I miss your question?
Do you see that as the debate, the lists, as between Ontario and Canada on the significance of the awards, and then of the Supreme Court of Canada decision, and then of the JCPC.
I think that's how I would frame it as well. We certainly rely on Award 15. And if Award 15 governs the way that we say it does, then that's the final decision that you need to worry about. There is no ability for Canada to make a claim against Ontario or Quebec for any amount of money in indemnification that you might order the Crown to pay. And that's where the overlap with the Constitution is important to understand. I'm going to go through that really carefully with you because it's important, I would submit, to get it right. It's the Constitution. But what the Constitution said, and you'll recall this because there was a lot of evidence on it, I'm sure, Your Honor, that the debts and liabilities existing at the Union were to be Canada's responsibility. So if Canada is the port of first call, as I referred to it when I stood before you back in January and made Ontario's opening statement, excuse me. If that's how the Constitution was meant to work, then a debt or liability, and both I going through the decisions that we say bind, and also Mr. Marcello will address contingent liabilities and crystallization of debt. But it's certainly our position that liabilities in Section 111 is broad enough to include those that had not yet crystallized at the point of July the 1st, 1867. So if Canada then became the port of first call, then the direct payment, the obligation for direct payment is entirely set out in that provision. And Canada has to pay directly, but Canada does have, we concede, it's common knowledge, I think, that there's a right of indemnification. But you only get there if you decide that the parties, because of all of the surrounding circumstances that happened leading up to that point in time, and because of all of the decisions that had found that that was so, that Section 111 and 112 were the guiding provisions of the Constitution that guided these debts and liabilities. If you decide that Award 15 didn't matter, then you're in that 111, 112 framework. Then we say that Canada only has a right of indemnification, but they must pay directly. Does that answer your question?
Somewhat. I was, it's not so much that I was giving you what my understanding of what either the Constitution or the orders make. It was on your point that Canada entered into the consent award with knowledge that increased annuities beyond $4 were, I'm just looking for your words.
They were possible. And Canada knew it, we say the evidence shows.
That Canada knew it.
That's right.
So
I think your question then might be.
So I'll just signal to you that that's a big question for me. It is a major question as between crowns.
Yes,
And
I
so
understand now.
I'll need to hear you on that.
So let me try to answer it briefly with the added point that I will be developing this. We do say that Canada knew that, and we do say that Award 15 did not just intend to go up to $4 per person. And it was made with the full knowledge and intention that there might have been some different views on that, but there was certainly evidence that Canada was aware of, directly aware, I might say, of possibilities of more than that. So I'll start with Award 15 then. And I've said, of course, that it's a final court order. Let me develop that with you. Award 15 contains a full and final release of Canada's claims against Ontario and Quebec for any increased annuities that may be augmented under the treaty. We say that it was negotiated, it was consented to, it was requested by council, and it was signed against the backdrop of the binding Supreme Court of Canada and JCPC determinations that Canada was that port of first call, that they were responsible for direct payments. Now, I'm cognizant too, and I'll pause here for a moment, Your Honor. You mentioned in a recent CMC to all parties before the closing submission started that you'd like references as often as possible to where things are in our materials.
No, it was
Our
just your
pleadings.
pleadings for the purpose of your submissions,
Yeah.
your written submissions. So if,
So in our reply, we certainly tried to do that. And there's been a couple times when we've footnoted to our reply, obviously not meant as authority for an argument, but as trying to signal to you where it was. So let me tell you right now that the Award 15 submissions that I will make, paragraphs 47 through 49 of our amended statement of defense to the plaintiffs address it. And in our amended defense to the cross-claim, you'll see it at paragraphs 14, and paragraphs 14 have many parts, subparts to it. It's covered through D through G.
and I must say, I only made that with respect to what claims you are making, not reference
see.
to any.
We might have
fact.
misunderstood you on that.
All right, thank you.
So if we turn to the compendium that has been filed up for Crown allocation, Exhibit MM, and we turn to the very first tab, Your Honor. This is Award 15, the beginning of it, and I'd like to ask my colleague to pull up page 3 of document, or the compendium, excuse me. I'm going to try not to misspeak often as I just did. So there's a bunch of different numbering. Most of these old pages and documents have different page numbers. Sometimes they're not quite legible. We've numbered the compendium as best as we can as well. So when I say page 3, it's the number that we've added. It looks like it's page 4-5 in the double spread that you might have before you in hard copy.
Thank you.
So on the left-hand column, we see the recitals continue. And we see in highlighting on the left-hand column, the introduction of the arbitrators by name. And they say that they do award, order, and adjudge. They go through paragraphs 1 and 2 respecting the arrears issues that had been put before them. And then in paragraph 3, the top of the right-hand column, it says this. With respect to the said treaties, there be entered and charged in the province of Canada account against the said province as represented by the provinces of Ontario and Quebec, and as of the 31st day of December, 1892, the sum of $205,000 in extinguishment forever thereafter of any claim by the Dominion of Canada on behalf of the said Indians for increased annuities under the said treaties. Your Honor, it's our submission that that language could not be more clear. $205,000, which was to be charged to the UPC account as of a certain date, Canada forever extinguished any claim it could have against the 2 new provinces respecting increased annuities under the Robinson treaties. There's no reference to any limit, much less a $4 one. Now, my friend for Canada called this award irrelevant. She said it was a tidy up document, I believe, from the OICs. It's our submission that it's neither. It's neither, Your Honor. It is the final award respecting Robinson annuity treaty payments and the liability for them from the statutory arbitrators. And we say that it is the instrument. Award 15 is the instrument that this court must interpret in order to determine if Canada fully released Ontario and Quebec from further claims that it could have against them. So why do I say that it's the instrument to be analyzed? Well, the legislation enabling those arbitrations tell us so. You'll recall evidence, Your Honor, from the various historians that testified before you in June, that in around 1891, within a few months of one another, Ontario, Quebec, and Canada each passed parallel legislation enabling this new statutory arbitration panel to be created. Sometimes it's referred to by my friends and I as the statutory arbitration, sometimes the Dominion provincial arbitrations. It's all the same thing. And it was specifically struck, if I may say that, to finally and conclusively settle the UPC account and the accounts of Ontario and Quebec. And ultimately, the statutory arbitrators made 19 awards. It's another important thing to keep in mind as we go through this, because many of them build on one another. Now, the legislation I said was parallel. I've included Canada's in our compendium at tab 2. If we could look at that. I'll be coming back to this on a few different occasions during the course of my submissions, Your Honor. But I'd like to turn your attention to the second page of this tab. It's our numbering 15, and direct your attention to section 8. It says, we've highlighted it for you, the appointment of the said arbitrators by order in council. And I might pause there to just say that that's not the order in council that you've heard anything about.
Excuse me.
Bless you.
Thank you.
That was this order in council distinct from the one that you've heard submissions on. It was to make the arbitration panel. The appointment of the said arbitrators by order in council and their award in writing shall be binding on Canada, save in case of appeal on question of law, in which case the final decision thereon shall be binding on Canada. Now, lest I be taken to suggest that this is only binding on Canada, I do repeat that Ontario and Quebec had similar legislation. Section 8 said that it was binding on the respective governments also. But the point I want to make to you today about Canada's legislation is that it was in force when Award 15 was requested. It was in place and in force when Award 15 was signed. And interestingly, it is still in effect today. So we say then that the award made pursuant to that legislation, and that was never appealed, is binding on Canada. Now, I want to spend some time looking at Award 15 and addressing Canada's submissions that really what governs is the OIC. As I understand Canada's arguments, it's that the settlement did not, could not settle further amounts that may be owing beyond $4 per person. In support of that, my friend directed you to Canada's OIC and Professor Messamore's opinion about the debt ceiling, and I'll address both of those points. Ms. Evans also argued that the arbitrators had no jurisdiction to make an award that would go beyond events that might have happened up until December 31st, 1892. And we say that none of these propositions are correct. So let me go through them. So I'll start with the submissions respecting Canada's OIC. Now, it's our submission, Your Honor, that the OIC is a surrounding circumstance. It is to be considered, but it's not, as I've stated, the instrument that governs the party's final relationship or that you are to analyze in determining what was settled. Surrounding circumstances are very important, though. And there's many in this case that can and must guide Your Honor's interpretive analysis, because they can shed light on what Award 15 was meant to do, but they can't overwhelm it. I'm going to spend some time talking about releases later in my submissions and taking you to the Corner Brook decision, the 2019 decision of the Supreme Court of Canada. I won't take you to the passage right now, but I will note that at paragraph 43 of Justice Rowe's unanimous decision, which we have included at tab 3 of our compendia, the Supreme Court of Canada said that the award or that the surrounding circumstances of a settlement of a consent order must be looked at. So that can provide some guide to you, Your Honor. Now, speaking about Canada's OIC, at the outset, I believe it's important to note that only Canada's OIC mentions $4 anywhere in it. Ontario and Quebec's do not. Canada's has lengthy recitals in it before the operative language begins. And the only reference to $4 in Canada's OIC is in those recitals. And it's in the context of describing what has happened to this point in time, as often recitals do. It set out that the treaty happened at all. It sets out what the treaty promise was. It sets out that increases can happen. It talks about the government actions taken to date, including an increase to $4. But the operative language makes no reference to it.
And where do I see the recitals?
Let's turn it up. It's a compendium, tab 1. It follows Award 15. So you'll find it on our page numbering 3, beginning. It's interesting how they used to kind of, without much fanfare, perhaps I might say,
I
describe
see
it.
it, you've highlighted it.
I have highlighted it.
Thank you.
So you see on the right-hand side of our page 3, these are the recitals. That among this and that at Confederation. And then we see a reference here to $4. It talks about what had happened in 1874. This is talking about the past. It's talking about what had happened. And then if we turn the page, the recitals continue on the left-hand side until they get to the highlighting that I've provided that begins the minister with the view.
Yes.
So we say that that's when the operative language begins. And of course, my friend took you to that operative language. Paragraph 2 talks about the capitalized sum of $205,000. Are you there? You saw that? And it says over the top of the next page that it will, well, it says at the bottom of the left-hand column, that that amount be taken to extinguish forever thereafter the annual charge of $8,200 on behalf of the said Indians for increased annuities under the said treaties.
Both of which sums were based on the presumption that the annuity was $4.
Well, we're going to talk about that because we certainly dispute that point.
Just a coincidence that those calculations work out to that?
Those calculations I'll take you through were based on a number that would make a settlement work. And just like all settling parties, they took calculated risks about what would get the job done. What we say that operative language tells us is that there was an intention to settle the issue of an annual charge. Settle the issue of an annual charge on the UPC's account for increased annuities under the Robinson treaties. Our submission that while this is an important surrounding circumstance, the non-operative recitals where we see the references to $4 are not sufficient and cannot overwhelm, to use the language of Justice Rowe, it cannot overwhelm Award 15's clear language, which is without limitation. And we say as well, and this, I think I started to make submissions to in answer to your question earlier to me, Your Honor. This court is of course held, and the Court of Appeal has affirmed that the language of the augmentation clause makes it clear that collective annuities could exceed $4 per person. And we know, or we will see, we've heard evidence on, other surrounding circumstances that we say demonstrate, when you read Award 15, that the parties knew this. And yet armed with this, or in spite of it, perhaps, they made a decision. Like all settling parties, they calculated their risks and they made a deal as between the governments. I'm going to spend time on other surrounding circumstances because we say that they're highly relevant also. They're not just merely interesting background facts. They help you and all of us here to understand what guided the parties to this point. Why did they get to this point? How did they make this determination to take these risks and to find these numbers? I'm going to take you through it.
I just ask a troubling question, troubling for me. As I recall, Ontario's position in stage one forcefully argued it was that there was no way that there could be an increase, that anyone intended or understood that there could be an increase over $4. And in support of that position, Ontario brought many documents that recorded the understanding of officials or actors, officials and other actors that supported that proposition. And now you forcefully argue that of course they all knew could be over $4. The only intervening event is the decision in stage one.
Well, it's interesting, Your Honor, that you said that Ontario said that they made submissions that their officials thought it was $4. I would suggest to you that that seems to have been the prevailing view, but it wasn't the only view. And you heard evidence in stage three. And
I'm talking about Ontario's position. Clearly, that wasn't the only view.
It's fine.
But Ontario argued forcefully. It's just a confounding position I find myself in, that Ontario now forcefully says that, well argued, says that of course everyone knew that the annuities could rise over $4. I'm sure you didn't, I'm sure you have anticipated this question, so I'll leave it with you.
I think, Your Honor, if I may, the evidence has demonstrated on stage 3 that Canada certainly had knowledge of that. We've heard from my friend, Mr. Schachter, even just last week, of petitions that are made to Canada. And I'll take you through, well, perhaps I don't need to take you through those ones in particular because Mr. Schachter has done a very able job, if I may say so, of doing so. But there's other documentation as well.
You don't want to comment on my point that the only intervening event is stage 1 decision or in the Court of Appeal decision.
I don't find it contradiction. I don't find it to be a contradiction.
Okay.
I think that there was a prevailing view, if you think about majority Crown actors perhaps working under the assumption that there was a different interpretation, but it wasn't the only view. And we see that in the evidence that we saw on stage 3.
Okay.
So then what kind of surrounding circumstances are important? And perhaps I'll just have an opportunity before we break for the day to tell you what we say they are and to perhaps just start. So I've taken you to the legislation authorizing the arbitrations. We'll spend some more time on that in a bit. There was also a joint submission that was put before the arbitrators in accordance with that legislation. It can guide us as well. There is quite a bit of documentation about the government's negotiations leading up to Award 15. And after all of these Supreme Court of Canada and JCPC decisions had finally told the government parties that Ontario alone was not responsible for making direct payments to annuitants. Canada was. So that's part of the backdrop. That's part of the surrounding circumstances that we say must guide you in your interpretive analysis. There's some other historical circumstances as well I'll take you through, and those include letters among government officials of the time leading up to Award 15. So I alluded a moment ago to Mr. Schachter and his written submissions, and I heard him orally say as well, speaking about Canada's particular knowledge of at least 2 explicit requests to Canada for annuities to be augmented above $4. I think I can summarize them very quickly without taking you to them, but I will provide you with some references. The first, of course, you've heard about the Simon Dawson letter. That was the 1873 letter that he sent to the Governor General of Canada and the federal cabinet members, that he accompanied, that the letter accompanied a petition from the Fort William First Nation. And that was advocating for increases to at least, but not limited to $4 per person. And in the interest of time, and because I do believe Mr. Schachter has gone through it, I'll just tell you that that is Exhibit 1-1093, and it's at Compendium Tab 16 of our Compendium Volume or Exhibit MM. And the Governor General of Canada's memorandum respecting that, respecting the Dawson letter and the Fort William petition, that's Exhibit 1-2303. And we've included that at Compendium Tab 17 of our compendium.
Thank you.
And again, the other example that Mr. Schachter took you to was in 1884, the federal Indian agent of the area at the time, Charles Skene, I think that's how it's pronounced, Skene. He reported to his superiors in the Federal Department of Indian Affairs that the Anishinaabe were calling for increases above $4 per person in accordance with the treaty promise. second document that I understood Mr. Schachter to be taking you to. It's exhibit, well, let me go back. We've included a transcription of it at our compendium tab 18. That's in the joint book of documents, and exhibit 1B, as in Barclay, -1200. Now, I understand that that transcription was actually prepared by my friends. We take no issue to it. It's much easier to read, I might suggest to you, than the actual document, which if you are interested in looking at, I've not included it in the compendium, but it's 1-1200. And then, of course, beyond these two requests, Your Honor's reasons in stage 1 found that there were multiple other letters or petitions by the plaintiffs to Canada for augmented annuities without reference to there being a $4 limit on the total annuities payable. And I might refer Your Honor to the stage 1 decision, paragraph 294. We've excerpted that at compendium exhibit MM tab 19. So then I think in response then, if I may, to Your Honor's question, given the plaintiff's request to Canada after 1867, when the Dominion was formed and before Award 15 was rendered, signed, that there was explicitly these requests for augmented annuities above $4 per person, Canada can't now plausibly argue that it thought that the augmented annuities under the treaty could only ever be up to $4, or that the stage 1 judgment is the only thing that ever told it so. Nor can Canada argue that only $4 was on the table, that only $4 was agreed to by the government parties. Because in the next surrounding circumstances I'll take you through, it's very clear that both the provinces of Ontario and Quebec were seeking finality. And you can't achieve finality if it's only up to $4, because of course there is the ability for it to go more, to go further. And that Canada and Ontario, Canada would have understood that Canada, late in the day, let me try again. Canada would have understood when we look at this surrounding circumstance, when we look at it, you will see, I suggest to you that Canada would have understood that Ontario and Quebec were looking for and expecting and agreeing to a settlement that was final for all time and included any and all annuities that could be payable, And I see it's 4:30 and I'm about to go into those documents. I wonder if you might wish to break for today and pick it up tomorrow.
Why don't we do that?
Thank you, Your Honor.
We'll break for the day and I'll just have a short chat with you all after we're off the record. Thank you.
We're all right.
Till tomorrow at 10.
This court is adjourned until September 21st, 2023 at 10 a.m.